Have you ever wondered, how does a defense attorney defend their client? There's lots of ways. This is Christina Williams with Just Criminal Law.
And David Mann, legal storytelling specialist. I'm always, of course, interested in, the story. And I think most people think I'm going to go to trial or whatever and get to tell my story, and that'll be my defense. But in talking to you through these videos and these conversations, I've found it's a lot more complicated than that. So what are the top ways that you use to strategically defend your client?
Well, there's basically 4 buckets that your defenses fall into. That is the lack of evidence, factual evidence. There's legal defenses, and there are these defenses that are, you're saying, okay, I did it, but I had a legal justification for doing it. And then there's just kind of a catch-all bucket that everything else fits into.
Okay, so the first one you said is factual defense. What's a couple of examples of that?
Well, say for instance, you have an alibi. That is, the state is accusing you of armed robbery for robbing a liquor store. But you can prove that you weren't even in the same county or the same state as where the offense occurred. And so you have an alibi defense. That is, it couldn't be you because you weren't even there.
All right.
Now, another example of this would be if there's a mistake as to your identity. That is, you are accused of, say, a hit and run, and your neighbor identifies you as the driver of the vehicle, when in fact, it wasn't you, it was your brother who was driving your vehicle at the time. So this would be a mistake of fact. And, it was your vehicle, and sure, the person was hit by your vehicle, but you weren't the driver.
Okay, so those are 2 factual defense examples. The next one you said was there would be a legal defense, which sounds like it would be the same thing, but what's the difference?
Sure, that's where you have a lack of intent. So part of certain crimes, the state must prove your intent, say your specific intent to do something. For example, if you're charged with first-degree murder for premeditated killing, so you planned to kill somebody, that's what the state has alleged, when really it was not planned and it was what they call heat of passion. So say your wife's in bed with your best friend and you walk in on them. Now, you may have suspected that they were sleeping together and had conversations of that effect with your wife, but you didn't know for certain. Well, the state can say that you had formed that intent to kill them if you ever caught them in bed together, versus a lesser charge to first degree, which is second-degree murder, where you have in fact killed that person, the person in bed with your wife, but it was in the heat of passion. That is, you had no ability to form the intent before you did the act. And so that distinction right there goes to the mens rea of the offense. And so, your defense attorney would say you're guilty of, if you're, the evidence is overwhelming, you're guilty of killing him, but it wasn't premeditated. So that's an example of your mens rea being a legal defense. Now, another defense is when there's not enough evidence. So at the end of all of the state's evidence in a trial, the defense will typically file a motion, or not file a motion, but argue a motion that the state has not met its burden of proof. That is, to one or more elements of an offense. So say, for example, you're accused of driving drunk and killing somebody. Now, in this particular case, yes, in fact, you had some alcohol in your system and you ran into somebody, but that person turned in front of you at an intersection. And so you would argue to the judge that the state hasn't met its burden of proof that this accident was the result of your intoxication rather than the person turning in front of you. And so in that particular type of case, we would argue that the court dismiss the case before we put on any evidence or before it goes to the jury because the state hasn't met its burden.
Okay. All right. So that's two of them, factual and legal. And then you said there's one where, I'm guilty, but there's a reason.
Yes. So you say I did it, but I was justified in doing it, and that's an affirmative defense. And the classic example is self-defense. So if, you get into a fight or an altercation with somebody, or say, they break into your house and you shoot them. Now, you're not contesting that you did the act, that you shot the person, but you're saying I had a legal defense to that. That is, I have the right to defend myself and I have the right to defend my property. And so this person breaking into my house put me in a situation where, I had to beat them up or I had to shoot them or whatever the case may be. That's an example of self-defense. There's also an example of necessity. So you broke into somebody's cabin in the mountains because your car broke down and you were freezing to death. Now, you admit, yes, I broke into their house, but it wasn't, an unlawful act. It was out of necessity. That is, I had to choose between freezing to death or breaking into their house.
All right, so that's factual, legal, and affirmative. I have a reason. What's this specialized category?
Sure, so it's an example of that would be someone's accused of a sexual assault by a date. They went out on a date and they didn't call the girl back, and she got mad, and her parents were mad at her, and you didn't call her back. And so she is trying to get out of hot water, and she says, well, yeah, but, I did something wrong, but, I was the victim of an assault. I was assaulted, and it kind of takes the heat off of her, and believe it or not, that happens. And your client is saying, whoa, wait a minute. We did have sex, but it was completely consensual. So, again, it's kind of affirmative defense in that, you're saying, yeah, I did it, but she consented. So that's an example. Sometimes there is like a case where you have a double jeopardy issue. That is, the state tried to take two bites out of the apple. We say that you only get one shot at justice, meaning your case should only go to trial one time. But sometimes extenuating circumstances and the state tries to take two bites at the apple, and that's called double jeopardy, and that's a defense as well.
All right, so there's so much more to defending yourself or defending, your case than just telling your story, meaning you're going to need a lawyer if you're in a situation. So how do they get in touch with you for that?
We'll include a link in the description where they can call, text, or chat with a member of my team anytime, day or night. Here at Just Criminal Law, we know you only get one shot at justice, so make yours count.